What are the unintended consequences of having a joint bank account or joint account? Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning lawyer, and I would like to tell you my thoughts on this. This happens all the time. I'm meeting with, usually it's an elderly uh, mother or father, typically they're widow or widower, and I say, well, tell me about your bank accounts. Do you have any beneficiaries on there or things along those lines? And they will go ahead and say, well, I have my daughter as a joint owner on the bank account. And I say, well, that's great, but do you know what that means in the long run? Here are the unintended consequences. Typically in the conversation, I'll hear something to the effect like, my daughter knows what to do if there's any money left after I pass away, and she will do the right thing. She will give it to my kids, or I'll split it between the kids or the grandkids. And that's fine and dandy, but you don't know that that's the case, because once you pass away, the bank account owner is the daughter. It's the first thing. The second thing, and even more critical for some folks, is the fact that if the daughter is a co-owner, then that's actually her money also. She could go in there and spend the money, or that money could potentially be captured by creditors. So this is how it would work. Say there's a credit card judgment against the daughter. She has to go into court, and under oath, she's going to be asked questions. Do you have any bank accounts? Do you have any bank accounts which you own? And then she's going to have to say, yes, I have a bank account at this bank, and I'm the only person on it. And I have another bank account, and my mother is the joint owner on that account. You see, legally, she actually has a right to the funds in the account, and they can go ahead and try to capture that money to make her pay the debt. There are possible things that can be done in order to combat that, and that is you'd have to show that the daughter did not put any money in the account, that it was really only mom's money, and it was done for the convenience, but that's talking about lawyers, lawsuits, and a whole bunch of strife. The easier way to do it is, number one, if you want to make the daughter a signer on the account in order to help you pay the bills, that's okay. If you want to give the daughter a limited power attorney or a full durable power of attorney so she can do your banking, that's okay. Protects it against creditors. If you want to, but the safest way with the bank account in order to protect from creditors would be to have the daughter or your kids as beneficiaries on the account. That way, when you pass away, the money automatically, the account automatically transfers to the beneficiaries once they show the bank that you have passed away. So there you have it. Many folks think that this is the easiest way, just to put a kid on as a joint owner or co-owner, but it can have a ton of unintended consequences or inattended consequences, or consequences that could be detrimental. If you have any questions, you can always reach out to me. I am Guy DiMartino. Have a great day.